On June 13, 1866, about 1 year after the Civil War had ended, Congress passed the 14th Amendment to the Constitution. Although slavery was abolished, the power structures that had animated the pre-war South began to reassert themselves. Southern states began electing former officials of the rebellious Confederacy to represent them in Congress, and passing laws restricting the rights of black people. Fearful that the South would deprive the newly liberated slaves of their civil and political rights, Congress sought to enshrine these rights in the Constitution by prohibiting state governments from denying any person the equal protection and due process of law. Section 3 of the new amendment included a disqualification clause, intended to prevent former public officials who had violated their oath of office by joining the Confederacy from serving again in public office. Today, under very different circumstances, the disqualification clause is again in the news. In a law review article, 2 law professors recently argued that the clause constitutionally bars former President Donald Trump from public office, including the office of President of the United States, because of his role in the aftermath of the 2020 elections and the events leading up to the January 6, 2021 attempt to obstruct Congress's certification of the election results. In the article, authors William Baud and Michael Stokes Paulson employ legal and historical argumentation to demonstrate why the former president's participation in the attempted overthrow of the 2020 presidential election disqualifies him from holding office under the post-Civil War era amendment aimed at former Confederate officials. Moreover, this argument is not merely theoretical. In 2022, a New Mexico County Commissioner was removed from office by a state court for engaging in insurrection by participating in the January 6th Capitol riots. More recently, a Republican candidate for president filed a lawsuit to prevent Trump's name from appearing on the New Hampshire ballot on 14th Amendment grounds. Likewise, public interest groups have petitioned state officials asking them to disqualify Trump from running for president and to remove his name from state ballots. The disqualification clause states that no person may hold any federal or state office who, having previously taken an oath to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. Baud observes that the clause is rarely invoked because insurrection and rebellion in the United States are rare. But while the clause was intended to deal with the problem of Confederate officials serving in office after the Civil War, the text of the amendment is not limited to any specific act of insurrection or rebellion. He argues that Trump, having sworn in his presidential oath of office to support the Constitution, subsequently either engaged in insurrection or rebellion himself or gave aid and comfort to enemies of the Constitution. Therefore, he concludes that he's ineligible to be President of the United States. However, constitutional analysis is rarely that simple. Legal complexities arise from the proper construction of the second part of the clause. First, what is an insurrection or rebellion against the Constitution, and who can be considered enemies of the Constitution? Second, what constitutes having engaged or given aid and comfort to such attacks? For purposes of Trump's eligibility for office, the first question relates to whether the events connected to January 6th rise to the level of a constitutional insurrection or rebellion, and the second relates to Trump's role in these events. Baud and Paulson engage in an originalist analysis, looking to the contemporary usage of insurrection, rebellion, and other key terms at the time of the amendment. Their conclusion is that Section 3 sets forth a broad disqualification from office, using insurrection and rebellion as sweeping terms to cover several different characterizations of major collective resistance to the authority of the government under the Constitution. Likewise, they conclude to have engaged in and to have given aid or comfort were understood at the time to encompass an incredibly broad sweep of voluntary conduct that provides support, material assistance, or specific encouragement to such actions. Their conclusion is that the efforts to reverse the election results and install Trump as president despite his electoral loss constitute insurrection or rebellion per the meaning of the disqualification clause. Likewise, they conclude that Trump's actions manifestly demonstrate that Trump himself deliberately set out to overturn the results of the 2020 presidential election. The bottom line, they say, is that Trump both engaged in insurrection or rebellion and gave aid and comfort to others likewise engaged. Therefore, if the public record is accurate, Trump is ineligible to again become president under the Constitution. However, a major hurdle to applying the disqualification clause to Trump or anyone else stems from the clause's lack of procedural specificity. The clause does not entail any process for determining when an insurrection or rebellion has occurred, or which body of government is responsible for adjudicating who should be disqualified. A circuit court in 1869, noting the absence of prescribed procedure, held that before any sentence of exclusion can be made to operate, proceedings, evidence, decisions, and enforcements of decisions, more or less formal, are indispensable. And these can only be provided for by Congress. The requirement that Congress must pass a law to enforce the disqualification clause is based on the theory that the clause is not self-executing. A provision is self-executing if it does not need an act of Congress to determine how the directive should be implemented. While Baud and Paulson disagree with the Circuit Court's reasoning, not all have been convinced. Even many Democratic legal experts concluded in the aftermath of January 6th that Trump could not be disqualified without congressional action, because the disqualification clause was not self-executing. Moreover, even if the clause were self-executing, the question of legal process remains. The clause may be binding on its own, but who is bound to enforce it, and what standards should be applied? Baud and Paulson argue that state and federal officials are responsible for determining whether candidates meet eligibility requirements for president, and so may likewise determine if a candidate is disqualified under the 14th Amendment. But this raises a series of related questions. May a state official simply declare that Donald Trump has engaged in insurrection without Trump having first been convicted of the crime of insurrection in a court of law? Even those sympathetic to the originalist reasoning are wary of empowering secretaries of state, often partisan politicians, with such unilateral power. If a state official does not act, who may challenge a candidate's qualification for the ballot in court? Under the doctrine of standing, only parties that have a personal stake in a dispute may sue to vindicate that harm. A Florida court recently dismissed a January 6th related challenge to Trump's eligibility on the grounds that an individual citizen who has no stake in an election other than being a voter does not have standing to challenge a candidate's qualification for office. Similarly, in the run-up to the 2022 midterm elections, the Arizona Supreme Court rejected a petition seeking the removal of Republican candidates from the ballot on the basis of alleged participation in the events of January 6th. The court held that Arizona law authorizing challenges to candidates is limited to challenges based on qualifications as prescribed by law, and does not include the disqualification clause. Opponents of the disqualification argument also point to pressing political and societal factors to consider. They note that many view the events of January 6th as a protest gone too far, or a riot, but well short of an insurrection or rebellion. With this lack of consensus and widely divergent perspectives on the significance of what transpired, removing Trump from the presidential ballot on the say-so of partisan officials could be catastrophic for a deeply polarized nation. It would be seen as riding roughshod over the principles of free speech, due process, and the democratic choice of political leadership, and would give way to retaliatory efforts to disqualify Democratic candidates. For these reasons, one legal scholar urges a reading of the disqualification clause in the narrowest, most precise, least susceptible to abuse manner, arguing that in the absence of actual engagement in actual insurrection, judged as such by competent authorities, we should allow the American people to vote for the candidate of their choice. As the election season nears, there is a distinct possibility that Trump could be disqualified from a state election ballot by a state official who finds the disqualification clause arguments legally persuasive. It can be safely assumed that an immediate appeal would bring the matter before the courts, with the Supreme Court likely to be the final arbiter as to whether Trump's name may be removed from the ballots. This court would likely be reluctant to allow state officials acting on their own volition to make such consequential determinations regarding a candidate's constitutional standing to run for office. Still, given the unprecedented nature of the issues, and the strong constitutional arguments raised by scholars weighing in on both sides, the choice facing the court could be momentous for the country.